Today's video is all about the SEC, guys. They are pissed, right? But remember, Gary and everyone else involved, they are just acting. The reason being is because we're about to expose them all. Check this out. SEC vs. Ripple. Gary Genzer did say a while back ago, if you want to regulate, then regulate. Put in the hard work to build a framework and set guidance, as so many other G20 countries are already doing. The 27 EU member countries can agree on a set of rules with MiCA. What's stopping the United States? You want me to answer this question from Gary Genzer? This is what's stopping the United States. We still haven't seen the crisis occur, right? The collapse occur. I could basically guarantee, not financial advice, right? Nothing is really a guarantee, to be honest, but after the collapse is when they'll throw out regulations, right, for the crypto sphere. The reason being is because during the collapse, 99.9% of these S coins and meme coins will go away to the shadow realm, right? The Grim Reaper will take them out. This is where you will be the catalyst. You will scream and cry out for these government agencies to regulate the crypto sphere. And they'll comply. They'll be like, oh, fantastic. We will do it in a second. In the blink of an eye, they'll bring out regulations. Out of nowhere, by the way, all they need is a problem, reaction, and a solution to implement whatever plans they have going on, right? So this is quite clear. What do we see right here? Just in a couple of hours ago, SEC says judges ruling that XRP is not a security was wrong. What? Whoa. Guys, it's accelerating, guys, right? This is crazy. So, oh, well, they say that, right? Check this out, though. From Crypto Airy, the best XRP 29 seconds you'll hear today, because Attorney Jeremy exposes them all, right? So there's going to be a train of connections here. Pay very close attention. It seems as the SEC wants to stop the XRP train or rocket ship, but it won't.
And she ruled on this XRP is not a security in a very interesting way. She quoted other cases which say kind of the same thing. And so it's called what's called dicta because it's not an essential part of her order, but it is in there. I don't think you can appeal that. I don't think that's appealable. I really don't. I don't think that any appellate court can touch that part of the order which says XRP in and of itself is not a security, which is really what's important for the XRP holders.
Yep, exactly. So Gary Genzer is obviously pissed, guys, right? The good news for XRP holders in the summary judgment motion's decision was without doubt the words, quote, XRP as a digital token is not in and of itself a contract, transaction, or scheme that embodies the Howey requirements of an investment contract, end quote. The even better news is that this comment should stand even if the SEC was to appeal and convince the Second Circuit Court that programmatic sales were investment contracts. It was not the issue Judge Torres had to decide, but she made the comments and gave clarity that the token XRP itself is not a security. This is where it's game over for the SEC, guys, right? And now, what about these other coins, though? Check this out.
But what the judge says here is that you have to analyze every sale in and of itself as far as XRP, the digital asset. And that's as far as this ruling goes. So it's very clear as XRP. It's not so clear as to any other digital asset.
It's not so clear to as to any other digital asset. Do you guys see how XRP has been first in the gate of clarity, and it was the first one out as well? Think about it, because let us now talk about what's happening with SEC and their comments here. XRP community in the SEC vs. Terraformer Labs Do Kwon case, the SEC has filed a pleading discussing Judge Torres' decision in the SEC vs. Ripple, in which it states that SEC staff is considering the various available avenues for further review and intends to recommend that the SEC seek such review. Pleading below, quote, SEC says ruling was wrong, signals it will appeal, unquote. Wow. SEC knows XRP is not a security, so them trying to appeal Judge Torres' decision is flat out dumb, right? Check this out. So supposedly the Wall Street Journal came out with this, published this today, right? A couple hours ago, basically 2-3 hours ago. SEC says XRP ruling was wrong, signals it will appeal. Wow. The Securities and Exchange Commission said Friday that a federal judge erred when she ruled against the agency in a landmark crypto case last week and signaled that it will appeal the decision, right? Now, United States District Judge Annalisa Torres sided with Ripple Labs that roughly half of its sales of cryptocurrency XRP didn't violate investor protection laws. Her decision gave hope to other defendants who are fighting the SEC over their sale of cryptocurrencies, which the SEC says are often illegally sold securities. Here comes Do Kwon, the jailed co-founder of crypto company Terraform Labs, is one of the defendants trying to use Torres's ruling to beat an SEC lawsuit, right? So this case, XRP winning is literally helping everyone else. People still hate it. If you go back here, so supposedly this is the case right there. Contrary to defendants' assertions, much of the Ripple ruling supports SEC's claims in this case and rejects arguments defendants have raised here. Let's go down here. However, with respect to programmatic and other sales, SEC respectfully avers that Ripple conflicts, states that Ripple conflicts with and adds baseless requirements to the Howey and its progeny. Respectfully, those portions of Ripple were wrongly decided and this court should not follow them. SEC staff is considering the various available avenues for further review and intends to recommend that the SEC should seek such review. Right now, so I don't get it, guys. Right, this is a weird tactic that they're going out on and about. Are they still trying to delay? Right, the delay mechanism is quite crazy, but it doesn't matter because XRP is literally put in law that it's not a security, right? So no matter what they say, guys, right, the SEC is trying to buy time here. Now, XRP is not considered a security. A judge concluded last week that the sales of XRP token directly to institutional investors violated the SEC's rules, while offering to retail investors on exchanges did not. Exactly, guys, right? Now, respectfully, those portions of Ripple were wrongfully decided, and this court should not follow them. What? And this court should not follow them? That's crazy. SEC staff is considering the various available avenues for further review and intends to recommend that the SEC seeks such review, right? The SEC adds that it improperly transforms a decades-old test for determining when assets are securities. But remember, the Howey test was literally created when, guys, right? It was the 19-somethings. 1930s, I forgot, guys, but literally in the 1900s it was created. How are they still using those laws and applying it to digital assets, right? Which this type of technology was born a decade ago. Think about it. Doesn't make sense at all, right? So they're out of the loop, guys. Now, the agency asked the court to reject that part of the decision, right? Wow. Now, it's unknown how the SEC appeal will carry on in the court, or if they will return to the Ripple ruling after the new filing. If so, the victory for crypto will not last long if the case resumes. But check this out from Eleanor Tourette, because the thing to know is that this judge's decision is going to be law of the land for the next 2 to 3 years, because it's going to take that much time before it gets to the second circuits, right? Basically years we're talking about. I see a lot of questions about the Ripple vs SEC appeals. Here's my thoughts, right? First timing, most appeals happen after the case is completely finished, which the Ripple case isn't, right? As you guys can see. So there's still time. Now, after the final judgment is entered, either party has 60 days to appeal, right? We don't have a final judgment yet. So an appeal of Judge Torres' order would be an interlocutory appeal, as far as I can see in the rules. You have 10 days to notice in that type of appeal, right? Now, if Judge Torres herself thought her ruling was so controversial or out there that it needed immediate review, she could have certified it for review to the appellate court, right? She didn't do that, which is another indicator that such an appeal might not be granted as well, right? So things are looking really good for XRP and Ripple. So will either party appeal, and why or why not? Most attorneys I've seen think the SEC will appeal. If I had to guess, I would bet neither side appeals, right? But we'll just have to wait and see, guys. Now, Second, the SEC has more to lose than gain by appealing. Ripple probably won't appeal if it could pay a fine, and if the ODL part of the ruling doesn't mess up its business, right? So, but it will connect to this next tweet from, again, Attorney Jeremy. Check this out, guys. Right, the chances of a settlement went up tenfold now.
The head of the SEC at the time. I mean, a lot can happen in 2 years. It just drags this whole process out. I think the problem with the settlement before now is, I think that my guess is that the SEC was going to Ripple and saying, we'll settle with you, but you have to register all of your XRP as a security moving forward. And that destroys Ripple's business model. So I don't think that it was really in the works. Now that we have a non-security designation, that might change. The chance of a settlement in this case just went up tenfold. This case just went up tenfold. This case just went up tenfold, from Wednesday until now. So we'll see what happens. There could still be a settlement in the works. The head of the SEC.
It still baffles me on how they say that the judge's ruling that XRP is not a security was wrong. What? Oh boy, I'm literally about to, I can't take it. Until the SEC can cite a single case where the Supreme Court's added a Howey factor requiring the judge to consider the level of sophistication of the investors entering into the common enterprise with the issuer seller, or a factor that requires the result after the Howey application to be consistent with the policy considerations behind the 1934 Securities Act, the SEC lawyers sound just like the crybabies they are. Exactly, guys, right? But everyone keeps bashing and hating the SEC. What about you have heard of this scumbag regulator, Gary Genzer. Now let me introduce you to J. Coward Clayton. Coward Clayton filed the lawsuit against Ripple, hurting XRP holders days before Christmas 2020, and ran out of the SEC doors the next day. Now that XRP has been declared not a security, he is nowhere to be found. He is a top contributor at CNBC and is often brought in to talk about crypto. He has yet to make an appearance with these people, right? Has Hinman or Clayton commented yet on the Ripple decision? Remember, Clayton was the only commissioner to review the Hinman speech. Remember, Clayton met Gary Genzer the day before Clayton filed the grossly overboard or broad complaint, absurdly alleging software code itself was a security as well, right? What's happening with him, guys, right? This is where we should pay attention towards, but all eyes on Gary, I guess. Last but not least, from X Anderson, SEC is truly desperate and pathetic. Exactly, guys, right? Let us see what happens. Again, things are moving very quickly, guys. We got to be on our tippy toes here. Not financial advice, not financial advice, not financial advice, and not financial advice. Let us be prepared. It still baffles me to this day. What's happening with SEC? I don't know, guys, but time is coming. Their time is coming, right? The corruption will be exposed. We'll be on the right side of law and history, as Brad Garlinghouse would say. 2023, the truth will come forth into the light. Not financial advice. But anyways, that's what you guys are amazing. See ya. Not financial advice. There we go.